Ontario's lowest paid workers received a raise on New Year's Day, but we are now hearing stories of companies changing employee benefits and raising prices to offset the new $14 minimum wage. To discuss the changes to Ontario's labour laws, we are joined by Alex Lucifero of Samfiru Tumarkin LLP. Alex, thanks for joining us this morning.
Morning, Annette.
Okay, so let's talk about what this means. First off, for people earning minimum wage, it's now $14 an hour.
That's right.
What does that mean in terms of any changes? They just have to automatically start seeing that on that first paycheck of 2018, which should be coming up?
That's right. So as of January 1st, 2018, the government in Ontario has increased the minimum wage, went up from $11.60 an hour on December 31st to $14 an hour. That's quite the jump. It's actually changing to $15 an hour on January 1st, 2019. So that's the big change. It's obviously caused some grumblings between employees and employers already. We'll get into that, I'm sure.
Some of the other changes that came into effect, vacation and medical family leave. Tell us a little bit about these.
So vacation is an interesting one. So for employees with 5 years or more of service with the same employer, your vacation is now increased from a minimum of 2 weeks to 3 weeks. So you get an extra week if you've been with the company for 5 years or more. Family medical leave, this is a big one as well. So as you can see, we've gone from 8 weeks leave in a 26-week period to 28 weeks in a 52-week period. That's quite the jump.
Yeah.
And just keep in mind that that's for critically ill family members. So it's got to be
significant, though.
Quite a significant change, but also it has to be a fairly drastic situation.
Okay, let's talk about what happened at a Tim Hortons in Cobourg, where employees were told they were going to start losing paid breaks, benefits, as a result of the owners having to pay more for minimum wage. Can a boss do this?
So this has been quite the story over the past week or so. It obviously blew up last week. The short answer to your question, Ed, is no. Employers cannot do that. I would say that this is, an example for employers of how not to handle a situation like this, how not to handle a change in legislation. You cannot, as a general rule, unilaterally change an employee's terms of employment without notice and without any kind of pay instead of that notice. That's what's known as a constructive dismissal. Employees don't have to accept that change. What they can do is either advise the company that they're not accepting those changes and say that, well, if you're going to enforce these changes, then I'm not going to accept that, and you've got to let me go. At that point, the employee would be owed their full severance package. The alternative, and this is a dangerous one, the alternative is accepting those changes, which is fine. In some cases, employees do want to keep their jobs. The problem with that is that once you've accepted those changes as an employee, you're going to allow the employer to do that time and again. So accepting this change on this round of adjustments to someone's pay opens up the door, and I would say kicks in the door for an employer to do that over and over again. So very problematic.
Okay, so if they do want to make changes, though, they have to notify the employees. Is that correct? Because they do have some rights to make changes, and employees have to either take it or leave it, as I understand? Definitely.
So there's 2 points there. Number one, the changes have to be significant in a case like this. So we're not talking about trivial changes like maybe you're changing the time of an employee's break. That's something that's fairly trivial. But any kind of significant change to the terms of employment does require either reasonable notice.
And what would be an example for that then?
It depends on the employee. So if you've got a longer-term employee who has enjoyed these perks for 15 years, let's say, maybe a year's notice is reasonable in that case. So we're talking about significant notice. We're not just talking about a couple of weeks.
Okay.
The alternative is that you can, as the employer, terminate that employee and then rehire them on these new terms.
Oh.
Now, that gets a little more complicated, but that's another option as well.
So they could take away, for example, companies are not necessarily required for a paid lunch break, for example. They don't have to pay them over their lunch break.
That's right. So we've got to be clear that none of these changes that this particular Tim Hortons franchise was trying to implement are illegal per se, right? So you don't have to necessarily pay an employee for their breaks. However, the key here is that this was a perk that the franchise was providing for as far as we know, for years and years. And so you cannot, again, going back to what I said previously, you cannot just unilaterally take those perks away without any kind of notice.
And on April 1st, Ontario's employment laws will require equal pay for equal work. What does that mean?
So this is something that addresses differences in pay for employees who are, for example, full-time versus part-time, or permanent versus casual. So it's to protect those employees that are temporary help agency workers, that are part-time workers, where it's possible that an employer is paying that employee less than what a full-time regular employee is making.
Okay.
And so in cases like that, you want somebody who is equally skilled, has the same amount of seniority, for example, as a full-time worker. You want that part-time worker to be treated just as fairly as the full-time worker. So that's what those provisions address.
Okay, Alex, some really good stuff. Thank you so much.
My pleasure,
Hopefully clarifying it for quite a few people who are affected by these new changes.